Hi, welcome again to the Basic Philippine Law and Jurisprudence channel. Our chapter, our chapter, our topic for today rather is capacity or full capacity to act. Full capacity to act uh, consists of two things. Juridical capacity, which is the fitness to be the subject of legal relations, and capacity to act, which is the power to do act. Juridical capacity, as you all know, is passive, meaning it is just the ability to become the subject of legal relations, become the object of contracts. Okay? It is the fitness to be the subject of legal relations. It is inherent in every natural person and is lost only to death. Okay? As you will know later, it is birth that determines capacity to act. So, as soon as a person is born, he immediately acquires juridical capacity, and sometimes in certain instances, even before birth. Okay? Capacity to act, on the other hand, is the power to do acts with legal effect. So it is the power to enter into contracts. It is the power to execute certain deeds with legal effect. Okay? It is acquired normally. The acquisition of capacity to act depends on the age of a person. Okay, if he has already acquired majority age, then he has the capacity to act. Okay, it is acquired and may be lost. Loss of capacity to act with respect to natural persons, it is also lost through death. Okay, and in certain instances or cases, there are restrictions or limitations on the capacity to act, such as when a person becomes insane, his capacity to act is therefore affected. Okay. The union of these two concepts, the juridical capacity as well as the capacity to act, pertains to the full civil capacity. Now, what are the restrictions on capacity to act? Okay. The restrictions on capacity to act are as follows. Article 38 tells us that minority, insanity, or imbecility, the state of being a deaf mute, prodigality, and civil interdiction are mere restrictions on capacity to act. So if you are a minor, you can have juridical capacity, okay, but you do not have the capacity to act. You do not have any power to enter into contractual relationship. In the same manner, insanity, if you're insane, okay, it reflects on the consent. Okay, because you are insane, okay, a person's mind is sick, and therefore it is a restriction on your capacity to act or to enter into binding legal relationships. The state of being a deaf mute. A deaf mute may either be sane or insane. Okay, if he is sane, he can act as a witness because in the cases that we will discuss later, okay, the capability of a witness to perceive and perceiving he may communicate what he perceived can be done even if a person is a deaf mute because he has other means of communicating the same. But if the deaf mute is insane, then he cannot act as a competent witness. A prodigality as well as civil interdiction. What is prodigality? It is a morbid state of mind and disposition to spend, waste, and lessen the estate to such an extent as to expose the family to want of support. Okay. Now, Article 39 speaks of other modifications or limitations on capacity to act. So aside from those which were already mentioned under Article 38, Article 39 is more comprehensive. because it speaks of the other limitations on capacity to act, such as family relations. Family relationship can be a restriction. As for example, if you are related by blood, you cannot marry your ascendant or your descendant within any degree. Okay, so that is a restriction on your capacity to act. You cannot marry your sibling, your blood sibling, whether you're full blood or half blood related, you cannot marry them. So there are certain restrictions with respect to family relationship. Alienage. If you're an alien, you cannot buy properties, real properties within the Philippines because of the restriction on the Constitution. Absence, if you are declared as an absentee, you can only act through an administrator. Insolvency and trusteeship. If you are an insolvent and you are declared to be an insolvent, then you can also only act through an administrator or the person who is in charge of liquidating your assets. Trusteeship also there is a limitation on the capacity to act. Okay, we now go to the first case of Continental Steel versus Montano. Okay, so this is a case involving a claim for death and accident insurance benefit, okay, which is provided under the collective bargaining agreement of the petitioner's company, the company Continental Steel, in which Hortiliano was employed. Now, the wife of Hortiliano became pregnant. Unfortunately, however, even before the said child in the womb of her wife was born, it had a death, an intrauterine death. He died inside the womb. Now, the Hortiliano is claiming for the death and accident insurance benefit of the child in the womb of his wife, because according to Hortiliano, the said child is a dependent and therefore is entitled to claim the said death benefits because he is his dependent, Hortiliano's dependent. However, his claim was denied because according to the denial of the claim, the child inside the womb of Hortiliano's wife has not yet acquired civil personality. Why? Because he has not been born. Okay, so according to the court, the issue is whether or not Hortiliano is entitled to the death and accident insurance benefit for the death of the child which was inside the womb of his wife. Okay, first, according to the court, the issue of civil personality is not relevant in this case. Articles 40, 41, and 42 of the Civil Code on Natural Persons must be applied in relation to Article 37 of the same code. We need not establish civil personality of the unborn child since his juridical capacity and capacity to act as a person are not in issue. It is not a question of whether the unborn child acquired any rights or incurred any obligations prior to his death that were passed on or assumed by the child's parents. So, the Supreme Court resolved this case by saying that the unborn child can be considered as a dependent under the collective bargaining agreement because a dependent is defined as one who relies on another for support. Now, even an unborn child is the dependent of its parents. Hortiliano's child could not have reached 38 to 39 weeks of gestational life without depending upon the mother. So the dependent may be the parent, spouse, or child of a married employee, or the parent, brother, or sister of a single employee. The CBA did not provide a qualification for the child dependent such that the child must have been born or must have acquired civil personality. Okay? People versus Aleman speaks of the qualification of a deaf mute to become a. According to this case, as you all know, being a deaf mute is a restriction on civil capacity. Okay? According to the case of Aleman, the fact that Mark is a deaf mute does not render him unqualified to be a witness. All persons who can perceive and perceiving can make known their perception to others may be witnesses. The inability to hear and speak may prevent a deaf mute from communicating orally with others, but he still may communicate with others in writing or through signs and symbols. Thus, a deaf mute is competent to be a witness as long as he has the faculty to make observations and he can make those observations known to others. In this case, Mark understood and appreciated the sanctity of an oath and that he comprehended the facts he testified thereon. Therefore, he is competent to become a witness. Okay. Martinez versus Martinez, this is a relatively old case, but this case defined what is meant by prodigality. Prodigality, as you all know, is a restriction on the capacity to act of a person. It defined prodigality as a morbid state of mind and a disposition to spend, waste, and lessen the estate to such an extent that it is likely to expose the family to want of support or to deprive the forced heirs of their legitimate. So in this case, however, the Supreme Court said that there is no evidence to show that there has been any perceptible diminution of the defendant's property. Okay. With respect to natural persons, what is the start and what is the end of the civil personality of a natural person? Okay, Article 40 tells us that birth determines personality, but the conceived child shall be considered born for all purposes that are favorable to it, provided that it be born later with the conditions specified in the following article. So the commencement of civil personality is the birth of a person. However, there are certain cases when even before the child is born, okay, he may be the subject of legal relations. Okay, so for example, he may be the subject of a donation. Okay, subject, however, to the colatilia that he be born later. Okay. So personality does not begin at birth, it begins at conception. The personality at conception is called presumptive personality. So the fetus is considered born under Article 41 if it is alive at the time it is completely delivered from the mother's womb. However, if the fetus had an intrauterine life of less than 7 months, it is not deemed born if it dies within 24 hours after its complete delivery from the maternal womb. So we have two kinds of birth. We have ordinary or extraordinary. With respect to ordinary, okay, if the fetus is born alive, even if it is alive only for 1 second, it is considered to have been born. However, if it had an intrauterine life of less than 7 months, then it has to be alive within 24 hours. Otherwise, it is not considered as born. Why is it necessary to determine whether it is alive or not? Because birth determines personality. So it is the start of personality. So the first thing that you have to consider is the period of gestation. If it is more than 7 months, okay, 7 months or more, okay, it is only necessary that the child is delivered alive, regardless of the period within which the child remained alive. It is considered as born. But if it has a gestation of less than 7 months, okay, then it must be alive within 24 hours. Otherwise, it is considered not to have been born. Okay. Now, what is meant by presumptive persona? So it means that a person which is still under the womb of the mother can be considered to have presumptive personality. Uh, It will be considered as born for all purposes which are beneficial to it, provided that it be born later. So it may receive the donations even before it is delivered from the mother's womb. Okay, he can be acknowledged even before he is born. Okay, Jealous versus Court of Appeals. So, this is a case in which um, there was a claim, okay, for damages, okay, for an unborn fetus. Okay, now it was it was the contention of the defendant that an unborn fetus cannot be awarded damages. Okay, precisely because civil personality has not yet commenced. So the Supreme Court said that uh, if no action for such damages could be instituted on behalf of the unborn child on account of the injuries it received, no such right of action could derivatively accrue to its parents or heirs. In fact, even if a cause of action did accrue on behalf of the unborn child, the same was extinguished by its prenatal death, since no transmission to anyone can take place from one that lacks juridical personality. Article 40 of the Civil Code expressly limits such provisional personality by imposing the condition that the child should be subsequently born alive, provided that it be born later with the conditions specified in the following article. In this case, there is no dispute that the child was dead when separated from its mother's womb. This is not to say that the parents are not entitled to collect damages, but such damages must be those inflicted directly upon them, as distinguished from the injury or violation of the rights of the unborn child, his right to life and physical integrity. So the claim for damages must be those suffered by the parents and not those suffered by the unborn child. Why? Because of the precisely of the fact that his juridical capacity has not yet commenced because he has not been born. Okay? We now go to the case of Kimiging versus Ikaw. A conceived child in this case, although as yet unborn, is given by law provisional personality of its own for purposes favorable to it. The unborn child, therefore, has a right to support from its progenitors, particularly the defendant appellee, whose paternity is deemed admitted. Just as even if the said child is only en vetre de samere, just as a conceived child, even if as yet unborn, may receive donations. This proviso, however, is not a condition precedent to the right of the conceived child. For if it were, the first part of Article 40 would become useless and ineffective. So if birth determines the personality of a natural person, what extinguishes this personality? Civil personality is extinguished by death. So the effect of death upon the rights and obligations of the deceased is determined by law, by contract, and by will. So what are the examples of the termination by loss. So when a person dies, the right to support ends because he is already 6 feet under the ground and there is no more need of support. Marriage also ends. The tie that binds the marriage ends. Tenure of public office ends. Property or estate left is still subject to tax, the estate tax. Okay? The estate, however, may be vested with a juridical personality such that in certain cases which survive the death of the decedent, that case may continue to be prosecuted against the estate of the decedent. Okay, Dumlao versus Quality Plastic. Okay, so this case illustrates to us the effect of death of a person. So in this case, Pedro Oria acted as one of the bondsmen whose land was sold had already died long before the filing of the case. Okay, so the bondsman has already died long before the case was filed. Now, the summons and copy of the complaint was not served on him precisely because he was already dead at the time of the filing of the case. Now, the Orias heirs sued to annul the judgment on the ground of lack of jurisdiction. The court said a court cannot acquire jurisdiction over the person of a party litigant who is already dead because he no longer has a civil personality. A man's juridical capacity, which is the fitness to be the subject of legal relations, is lost through death. Hence, no valid service of summons can be effected upon him, which will vest jurisdiction upon the court over his person. Okay, we have another case of SEC versus AZ Realty, which also illustrates to us how death extinguishes civil personality. So in this case, Luxin Garcia sought to revoke the incorporation of AC Realty on the ground of fraud. Now, what is the fraud that was allegedly committed? One of the incorporators, Pasita, had long been dead at the time of AZ Realty incorporation. Now, the issue is the inclusion of a dead person as an incorporator considered fraud in procuring a certificate of registration. Okay, the Supreme Court said that a deceased person like Pasita has no legal capacity to enter into contractual relations and cannot be the subject of a right. So how can he be an incorporator if he is already dead at the time of the incorporation? So juridical capacity, which is the fitness to be the subject of legal relations, is lost through death. Except to answer for debts legally demandable upon the estate, a deceased person cannot enter anymore into contractual relations. Okay. So we now move to survivorship or non-survivorship. Article 43 tells us that if there is doubt as between two or more persons who are called to succeed each other as to which of them died first, whoever alleges the death of one prior to the other shall prove it. In the absence of proof, it is presumed that they died at the same time and there shall be no transmission of rights from one to the other. The important thing to remember about Article 43 is that this provision only applies if two or more persons died simultaneously and they are called to succeed each other, meaning they are compulsory heirs. Okay? And there is doubt as to which of them died first because their death is almost simultaneous. So, if this is the case or if this is the scenario that persons who are called to succeed each other died in an almost simultaneous manner, okay, you have to prove which of them which among the two persons died first. Okay, why is it crucial? Because it is crucial because to determine if for example, if father and child, they are called to succeed each other. They died, for example, in a shipwreck. Okay, both of them died when the ship sank. Okay, so which of them died first? So you must prove as whether it is the father or the son which died first. In the absence of proof, they are presumed to have died at the same time, and there will be no transmission of rights from one to the other. Why? Because if it is proved that it is the father who died first, then the child will ultimately get his legitimate from the father, right? On the other hand, if it is the child who died ahead of the father, then the child, which personality has already been lost or extinguished because of his death, cannot anymore inherit from the father, right? Okay. So that is the reason why there is a need to prove which among these two persons died because they are called to succeed one another. Okay. What about those persons who are not called to succeed each other? Is there a presumption of survivorship? The answer is yes. Under the rules of evidence, Rule 131, there is a presumption of survivorship as follows. When two persons perish in the same calamity, such as a wreck, battle, or conflagration, and it is not shown who died first, and there are no particular circumstances from which it can be inferred, the survivorship is presumed from the probabilities resulting from the strength and age of the sexes, according to the following. If both were under the age of 15, the older is presumed to have survived. If both were above the age of 60, the younger is presumed to have survived. If one is under 15 and the other above 60, the former, meaning the one under 15, is presumed to have survived. If both be over 15 and under 60 and the sexes are different, the male is presumed to have survived. If the sexes be the same, then the older. If one is under 15 or over 60 and the other between those ages, the latter is presumed to have survived. Remember, you will only apply Rule 131 if the persons who perish are not called to succeed each other. Okay, we have the case of resurrection versus Javier. So in this case, Felisa made a will and then he left a legacy of 2,000 in favor of her brother Gil. However, Gil died even before the testatrix or even before Felisa made the will. So again, what is the result of death? It extinguishes the civil personality. So he can no longer be the subject of legal relations. So what will happen to the legacy of 2,000? It will be of no effect. It will be considered as void. Okay? He'll lack legal civil personality, which is extinguished by death, and therefore lack capacity to inherit by will on the ground that he could not be the subject of a right. They cannot even claim under the principle of representation because this takes place only in intestate succession. As the legatee died before the testatrix, he could transmit nothing to his heirs. The case of Joaquin versus Navarro. So this is a case involving simultaneous death of persons who are called to succeed each other, which happened during the war. Okay, however, there is a positive testimony as to which among these persons who are called to succeed each other died first. So considering that there is that positive testimony, it is proven by competent evidence as to who died first. So the presumption rule 131 will not apply because they are persons who are called to succeed each other. And there is proof as to who really died first. So in this case, the main question is related to the sequence of deaths of Joaquin Navarro, his wife, and their children, all of whom were killed in the massacre of civilians by the Japanese Manila. So, Article 43 and Rule 133 implies are intended as a substitute for facts and they are not available when there are facts. Okay, so it is believed that in the light of the conditions painted by Lopez, a fair and reasonable inference can be arrived at, namely that Joaquin Navarro died for his mother. Okay, so in conclusion, the presumption that Angela Joaquin died before her son is based purely on surmises, speculations, or conjectures without any sure foundation in the evidence. The opposite theory, that the mother outlived her son, is deduced from established facts, which, weighed by common experience, engender the inference as a very strong probability. So remember Article 43, if persons are called to succeed each other, there is no presumption as to which among them died first, and it must be proved by clear, competent evidence as to who among these persons died first. Okay, let us now go to juridical persons, okay, who are considered as juridical persons. First, the state and its political subdivision. The state republic of the Philippines, political subdivisions, the various local government units that we have, Nueva Ecija, Cabanatuan, Cebu, okay, and so on and so forth. Other corporations, institutions, and entities for public interest or purpose created by law, their personality begins as soon as they have been constituted according to. So corporations, maybe private corporations, public corporations, it may be non-governmental institutions, okay, they are also vested with a separate juridical personality. Okay. Corporations, partnerships, and associations for private interest or purpose. Okay. These are the persons who are considered as juridical persons. Their personality is separate and distinct from the persons who comprise these corporations and entities. Okay. What is the commencement of the juridical personality of a juridical person? Okay. The personality of a juridical person commences from the issuance of a certificate of incorporation. Okay, or in the case of the state and its political subdivisions, from the enactment and effectivity of its charter. Okay, there is also the so-called corporation soul. What is a corporation soul? The classic example of a corporation soul is the Roman Catholic Church. It is a person separate and distinct from the Pope or the Holy See. The Roman Catholic Church or any of its corporation souls duly incorporated in the Philippines, okay, is vested with a separate juridical personality. So the different dioceses within the Philippines, like for example, the Diocese of Cabanatuan, the corporation soul is the Roman Catholic Bishop of Cabanatuan. That is the corporation soul. Why is it considered as a corporation soul? Because the incorporator is only one. Okay, and that is the bishop or the pope, the case name. Okay. Nationality of juridical persons. What is the nationality of a juridical person? Okay. Juridical persons are governed by the laws creating or recognizing them. Private corporations are regulated by laws of general application on the subject, which is the Corporation Code, while partnerships and associations for private interests are governed by the provisions of this code concerning partnerships. Now, the place of incorporation is governed, the nationality rather. You determine the nationality of a corporation through its place of incorporation. Thus, if it is incorporated in the Philippines, then it is a Philippine corporation. What are the rights of juridical persons? So just like natural persons, not juridical persons are also endowed or vested with a personality separate and distinct from the persons comprising it. Okay, as such, just like natural persons, they may acquire and possess property of all kinds, as well as incur obligations, bring civil or criminal actions in conformity with the laws and regulations of their organization. Okay, so the power to acquire, the power to contract obligations, the power to sue. Okay, just like natural persons, juridical persons also have these powers. Okay. When does when can a juridical person be considered as dissolved? Okay. They are dissolved when there is another law or charter which dissolves these corporations, or if nothing has been specified in this point, then the property and other assets shall be applied for similar purposes for the benefit of the region, province, city, or municipality which, during the existence of the institution, derive the principal benefits from the same. Okay. Earlier, we discussed the powers of a juridical person, the power to sue, the power to acquire, the power to enter into contracts. How do these corporations do these things? Okay, the corporation exercises its powers through its board of directors, officers, or agents. Okay, when they are authorized by board resolution or by their bylaws. So they act or they do business through the board of directors, officers, or agents. Considering that the corporation has a personality which is separate and distinct from the officers, from the stockholders, from the board of directors comprising it, it can sometimes be used as a tool for fraud. Okay, that is the reason why we have the so-called doctrine of piercing the veil of corporate fiction. Okay, so in this case, in piercing the veil of corporate fiction, it is used only when the corporation is being employed as a cloak or cover for fraud or illegality or to work unjust. Okay, we will subsequently discuss cases, okay, involving the doctrine of piercing the veil of corporate fiction. Okay. Now we now have the case of Laureano, investment and development versus Court of Appeals. So the Laureano case tells us the lesson to be learned in this case is for a corporation to be vested with a separate juridical personality, it has to be first incorporated because the birth of corporation as a juridical person is from the moment of the issuance, the certificate of incorporation. So in this case, Lideco had no personality since it was not registered as a corporation. If petitioner really wanted to intervene, it should have used its corporate name as the law requires and not another name, which was not registered. So Lideco Corporation stands for Laureano Investment and Development Corporation. So it should have intervened in the name of Laureano Investment and Development Corporation. Okay. Another case is Wasing Hardware versus Mendoza. Can sole proprietorships vested with juridical personality? The answer is categorically stated by the court in the case of Wasing Hardware. Okay, there is no law authorizing sole proprietorships to bring suits in court. The law merely recognizes the existence of a sole proprietorship as a form of business organization. It does not vest juridical or legal personality upon the sole proprietorship nor empower it to file or defend an action in court. So the complaint should have been filed in the name of the owner of Wasing Hardware, who is a natural person. So sole proprietorships are not vested with a separate juridical personality. That is the lesson to be learned in Wasing Hardware. Okay. Missionary Sisters of Our Lady of Fatima versus Alzon speaks of a corporation by Estopel. So this is a case wherein Purificacion executed a deed of donation, conveying her properties to the Missionary Sisters of Our Lady of Fatima. At the time when the said deed of donation was executed, Missionary Sisters is still not yet incorporated as a non-stock corporation. There was no issuance yet of the certificate of incorporation, and therefore it had no juridical personality. So, not having a juridical personality, is it already empowered to accept donations? Okay, so the Supreme Court held in this case the filing of the articles of incorporation and the issuance of the certificate of incorporation are essential for the existence of a de facto corporation. It is the act of registration with the SEC through the issuance of a certificate of incorporation that marks the beginning of an entity's corporate existence. However, a review of the circumstances reveals that the application of the doctrine of corporation by Estopel is warranted. What is this doctrine of corporation by Estopel? It is founded on the principles of equity, and it is designed to prevent injustice and unfairness. It applies when a non-existent corporation enters into contracts or dealings with third persons, in which case the person who has contracted or dealt with a non-existent corporation is stoked to deny the latter's legal existence in any action leading out of or involving such contract or dealing, such that a person who has assumed an obligation in favor of a non-existent corporation, having transacted with the latter as if it was duly incorporated, is prevented from denying the existence of the latter to avoid the enforcement of the contract. So that is corporation by Estopel. In this case, the court accords upon an organized entity corporate fiction and juridical personality for the sole purpose of upholding the contract or transaction. Okay. Gesolbon versus Cyber 1 PH is a case which illustrates for us what is the doctrine of piercing the veil of corporate fiction. However, in this case, the Supreme Court held that there was no need to employ the doctrine of piercing the veil of corporate fiction. Why? Because For the purpose of employing the said doctrine, there is a need to demonstrate that the separate juridical personality of the corporation was used as a means for fraud. Okay, the Supreme Court found that fraud sufficient to warrant the piercing of the veil of corporate fiction was not present in this. Okay, the application of the doctrine of piercing the corporate veil is unwarranted. First, there was no evidence presented to prove that Cyber One was organized for the purpose of defeating public convenience or evading an existing obligation. Second, petitioners failed to allege any fraudulent acts committed by Cyber One in order to justify a wrong, protect a fraud, or defend a crime. Lastly, the mere fact that Cyber One's major stockholders are Cyber One AU and respondent MyFood does not prove that Cyber One was organized and controlled and its affairs conducted in a manner that made it merely an instrumentality, agency, conduit, or adjunct of Cyber One AU. So therefore, the doctrine of piercing the veil was not upheld in this case. Okay. Genuno Agro-Industrial Development Corporation versus Romano. In this case, the Supreme Court held that there is a need to pierce the veil of corporate fiction. Okay. A corporation is an artificial person invested by law with personality separate and distinct from its stockholders and from other corporations to which it may be connected. The corporate veil, however, may be pierced when a corporation is just an alter ego of a person or another corporation. The separate personality of a corporation is used as a means to perpetrate fraud or an illegal act, or as a vehicle for the evasion of an existing obligation, the circumvention of statutes, or to confuse legitimate issues. So in this case, the court held that there is a need to pierce the veil of corporate fiction. You go through, you pierce, you go through, you go inside the corporate fiction and examine if the corporate personality, separate corporate personality is being used as an instrument of fraud. In this case, the circumstances establish that both Genuino Eyes and the petitioner are using their respective distinct corporate personalities in bad faith and to confuse legitimate issues in the hope of evading its obligation to the respondents. When an affiliate company takes the cudgels for another, it means that both have a common interest. If indeed there was no commonality or intertwining of interest in frustrating the respondent's monetary claims, the petitioner and not Genuino Eyes would have posted a bond for its own appeal. The court cannot allow its intelligence to be insulted by Genuino's representation that it has a corporate personality which is separate and distinct from the petition, because both companies have pursued legal remedies for the benefit of each other and made representations that clearly defrauded the respondents. Hence, for purposes of this litigation and for the satisfaction of respondents' money claims, both Genuino and the petitioner shall be treated as one and the same entity and held liable solidarity for the state. Okay. With respect to Article 48 onwards, regarding citizenship, I will leave it to your constitutional law professor because that would only be a duplication of the topics that will be discussed primarily in your constitutional law subject. So that's it for today. Thank you for listening.